indicating that the decision to release Mr. Pistorius on parole needs to be reviewed, dated 19 August 2015. A letter from the review board to the legal representative of Mr. Pistorius, indicating that the board would consider the matter of his parole on the 18th of September. This letter was dated 16 September 2015. Form G303D, Correctional Sentence Plan, dated 22 October 2014. Form G303B, Admission Security Risk Classification, completed 3 November 2014. Form G303G, Pre-Placement Assessment Tool, completed by the Correctional Centre where Mr. Pistorius was incarcerated, dated 16 April 2015. A document entitled The First 1,000 Days, which sets out a program of intervention in the lives of disadvantaged children, conducted by the company Twin City Developments. I conducted a mental state examination, I conducted a risk assessment, I conducted a psychometric assessment, I conducted an assessment of possible criminogenic needs.
What is criminogenic?
It refers to those factors that might cause someone to commit an offence. And we distinguish between static and dynamic factors. So static factors would be things that you can't really change. In other words, if a person comes from a family that is riddled with crime or has committed various crimes in the past, and there's a pattern of that, dynamic factors refer to the more changeable aspects. The way an offender thinks, his values, his belief systems, who he relates to, all the factors that we can look at and perhaps change.
Thank you.
Continue.
Yep.
Issues addressed. Mental state examination of Mr. Pistorius. Excuse me, Marlene. Mr. Pistorius appeared adequately groomed. He spoke in a soft voice. His mood was anxious and depressed. His affect varied from being restricted to labile. His thought form appeared normal most of the time, but he tended to derail and become tangential at times. His thought content displayed preoccupation regarding the impending sentencing procedures, guilt, and his future. He appeared to have limited energy and his concentration wavered. He had no perceptual disturbances. He displayed signs and reported symptoms of post-traumatic stress disorder, anxiety disorder, and depressive disorder. His short to medium-term memory was compromised. His judgment was intact, and he had good insight. His manner was respectful and cooperative. At my request, he produced the medication for depression, anxiety, and insomnia as prescribed by psychiatrist Dr. Bosch.
If we may just stop there, just 1 point consideration given if it was possible to call him as a witness. What is your view on that, in view of his state of mind?
Currently, I don't think he is able to be a witness in this trial. His condition is severe.
I can't hear that.
I say currently, in my opinion, he's not able to testify, my lady. His condition is severe.
We move on to paragraph 2.2.
History and development of Mr. Pistorius. Family constellation and relationships. Mother. Even though there was never any violence or serious aggression between his mother and father, the couple divorced when Mr. Pistorius was 6 years old. Mr. Pistorius' mother did her best after the divorce and remained positive and strong, even though the family had to adapt to difficult circumstances, especially financially. She motivated Mr. Pistorius to live his life as normal as possible, in spite of the problems he experienced as a double amputee. She was, however, also an anxious person and got startled easily. She acquired a pistol when she met her husband and learned to shoot. After the divorce, she would become scared and anxious at times when she felt they were under threat. Unfortunately, there were a few incidents of crime that the family experienced directly or indirectly, and this exacerbated her anxiety. These experiences left a lasting impression on a young Mr. Pistorius, making him aware of his family's and his own vulnerability to crime and increasing his fear of being a victim of crime. The sudden passing of his mother when he was 15 years old came as a big shock to Mr. Pistorius and left him feeling traumatized and abandoned. Father. Mr. Pistorius had limited contact with his father after the divorce. His father became absent in his life, and their relationship deteriorated to the point where Mr. Pistorius emancipated himself at the age of 18 years. His bond with his father has never been healed to any meaningful extent. Mr. Pistorius found substitute father figures, mainly in his uncle Arnold, his housemaster at Pretoria Boys High, Mr. Anthony, his school principal, Mr. Schroeder, his coach, Mr. Lowe, and his manager, Mr. Van Sale. In this regard, he was fortunate to have strong, positive male figures around to assist and guide him. The involvement of these men seemed to have left Mr. Pistorius with values of integrity, respect, and discipline. Siblings. Mr. Pistorius is the middle child in a family of 3 children. He has an elder brother who is 18 months older than him and a sister who is 30 months his junior. The siblings stuck together and remained close through the years. Unfortunately, his sister recently left South Africa, mainly because the stress of the court case and the negative media and public attention became too much for her. This was experienced as a big loss by Mr. Pistorius, as he had a close bond with his sister, more so than with his brother. Family. There were close ties both within the nuclear family and within the extended family, and this has remained so in spite of the stress of the past 2 years. This is still the case, as is seen by the fact that Mr. Pistorius has relied on his family financially and emotionally over the past 2 years. He has been placed under house arrest at the residence of his uncle and aunt ever since his release, and is taken care of by them in most of his activities of daily living. I found it meaningful when I recently overheard Mr. Pistorius calling his aunt Mom. Early development. At the age of 11 months, Mr. Pistorius had a bilateral below-knee amputation, the result of a congenital abnormality he was born with. Although this procedure would have been traumatic, he was fortunate that his mother's presence and positive approach helped moderate the intensity of the experience and its psychological consequences. She encouraged him to participate in physical and outdoor activities, to live his life as normal as possible. She instilled in him the idea that God had a special plan with him, as there was a period when he repeatedly asked her if God had made a mistake when he made him. He became very independent, not allowing his disability to prevent him from participating in sport and play. School. Mr. Pistorius attended primary school in Pretoria without incident. He never displayed ill discipline, behavioral problems, or instability of mood. He was used as a role model for the other children at times and was always respectful. He enrolled for grade 8 at Pretoria High School for Boys. At that point, he lived with his father, but owing to poor care and non-involvement, he was admitted as a boarder halfway through that year. In February of his grade 9 year, his mother passed away of a brain hemorrhage. This presented as a huge loss to him, as she had been the most consistent, loving, and supportive figure in his life. With the help of his family, he worked through this loss, his natural resilience also playing a role. He had to work hard at his studies, but progressed without any incident. There were never any incidents of ill discipline, behavioral problems, or instability of mood reported during his primary or secondary school years. He was popular with fellow pupils and teachers and became a house prefect in grade 12, tasked with overseeing the grade 8 boys. There were never any problems with him in the hostel. He was known for his tremendous determination when engaged in a physically challenging task. Although he could misbehave at times, he was always respectful and disciplined. The period after grade 12. After grade 12, Mr. Pistorius enrolled at the University of Pretoria for a Bachelor of Commerce degree in business economics. However, the demands of his athletics career were such that he had to opt out in order to focus on being a professional athlete. His life became very structured and predetermined, as he had a rigorous and fixed training program, which included a strict regimen regarding his dietary and sleeping habits. He also had numerous engagements with sponsors, the media, and social events linked to his career. He received an honorary doctorate from the University of Strathclyde for his work in developing prostheses. He was voted one of the top 100 most influential people in the world by Time magazine. He also received keys to, amongst others, the cities of Rome and Genoa. He counted amongst his acquaintances presidents of countries, royalty, and elite sportsmen. More detail of his accomplishments can be found in Annexure D. All of this changed when the incident took place in, my apologies there, my lady, it states in my report 2014, obviously it must be 2013, line 247. All of this changed when the incident took place in 2013. One can safely state that his fall from grace was enormous. Although the media pressure became even more intense, it was now because of his infamy. The reaction of the world to this case is well known, and although he received support from many quarters, he was vilified and attacked by many, especially because the contention that he had intentionally shot and killed the deceased remained present until judgment by the trial court and even after that. He had dealt with the trial and all the circumstances surrounding it as best he could, but was unable to properly mourn the loss of the deceased. He was unable to attend her funeral or speak with her family in spite of requesting to do so. He was severely traumatized by the events that took place on the 14th of February, and there's another, it must be 2013, my lady, not 2014, line 257. He was severely traumatized by the events that took place on the 14th of February 2013, and I made a diagnosis of post-traumatic stress disorder and major depressive disorder at that time. He's currently still receiving pharmacotherapy and psychotherapy for these conditions. After his trial, he was incarcerated for 10 months at Kgosi Mampuru Correctional Center. He was due for release on correctional supervision in August 2015, but the Minister of Justice and Corrections intervened 2 days before his release date. He spent 2 more months incarcerated, after which he was released with strict bail conditions. His conviction for culpable homicide was successfully appealed by the state, and in December 2015 he was found guilty of murder by the Supreme Court of Appeals. He has been under house arrest at the residence of his uncle ever since, awaiting sentence. Relationships. Mr. Pistorius had various relationships since the time he was at school. Some were of short duration, based mainly on the need for companionship, especially after 2011, when his career as a professional athlete took off. He had a successful relationship of almost 5-year duration, which ended amicably, and they are currently still friends. During his career, he became prone to living the lonely type of life, often reported by elite athletes. It was also problematic that he would spend 4 months of the year in Italy, thereby losing contact with friends in South Africa. In these circumstances, it was not only difficult to fit in with a group of friends when he returned, but maintaining an intimate relationship was almost impossible. He was often approached by beautiful women like models, but never reacted to their offers. His experience was that many girls wanted to be with him because of his fame and the media attention he received. His relationship with the deceased, which started at the end of 2012, was probably only the second one where he felt trust, sincerity, and real companionship. Religion. Mr. Pistorius was brought up with strong Christian values. He attended the Methodist Church as a young boy and later moved to the Pentecostal Church. His mother was religious and attended various churches like the Assemblies of God or Rima Church. After school, Mr. Pistorius joined the Centurion Christian Church in Irene, Pretoria. He struggled to attend services as he traveled a lot, but would attend the Catholic Church in Italy while he was there. He prayed daily and still does. He held regular prayer and Bible discussion groups at his residence with fellow Christians. Although he would not force his views on others, he preferred that everybody hold hands while he prayed before a meal at his home. The deceased shared his views on religion. If anything, the experiences of the past 2 years have deepened his spirituality. He has expressed the wish to make himself available and work through the church to help others. He believes that his life is in the hands of God and that he will be used in some way to make the lives of others better. He has found some solace in the fact that the deceased is with God. Substances. Substances have never played a role in the life of Mr. Pistorius. Save for some experimenting with cannabis whilst being at high school, he has never used or abused illicit substances. Legal. Mr. Pistorius was convicted of culpable homicide and of the negligent discharge of a firearm in a public place in 2014. He was convicted of murder in December 2015. Prior to 2014, he had no convictions. Sport and hobbies. The achievements of Mr. Pistorius as an athlete is well known. Detail of these achievements are contained in Annexure D. Mr. Pistorius was a gun collector, but has now distanced himself from this hobby. He is adamant that he never wants to touch or handle a firearm again and has sold all his firearms. Since the events of 20, and there's another 2014 that should be 2013, my lady, line 320. Since the events of 2013, he became traumatized when he hears the sound of gunfire, even if it's part of a film he is watching. In many instances, these sounds or scenes depicting a murder would trigger sensory recollections of the events, especially of an olfactory nature. This phenomenon is not uncommon in post-traumatic stress disorder. Relationship with the deceased, Mr. Pistorius was genuine in his affection for the deceased, and indications were they had a normal, loving relationship. They had plans for a future together. Although their relationship was still young, there were no signs of abuse or coercion like those often found in abusive relationships. I'll continue with psychometric assessment. Shall I continue with?
Yeah, thank you.
Yes, sorry. Psychometric and risk assessment. I conducted a psychometric assessment of Mr. Pistorius. The results obtained after administration of the Minnesota Multiphasic Personality Inventory 2, MMPI-2, are reported below. The MMPI-2 is an objective test designed to assess a number of the major patterns of personality and psychological disorders. It is the most widely used inventory internationally and has appeared in research reports for more than 20 years, with established reliability coefficients of 0.83 for internal consistency, 0.75 for test-retest reliability. The various primary clinical scales of the MMPI-2 are contained in Annexure C. Results of the MMPI-2. Mr. Pistorius' results were as followed. The ones indicated in bold are the ones that are relevant, my lady. And the first 6 ones, VRIN, TRIN, F, L, K, and S, form a group. VRIN 47, TRIN 49, F 47, L 54, K 46, and S 58. Then at line 353 we get... Yeah.
What is that group?
Those are control measures. Those are measures that are built into this test to see if the person is responding openly and honestly, or if he's trying to portray a more positive or a more negative approach, or that there's some consistent pattern, not of lying, but of trying to manipulate the test. So those are control measures built in to see that the protocol is valid. And we then get to the clinical scales at line 353. HS68 was high, D for depression, 84 was
sorry,
very...
what is HS?
It refers to a focus on the body. So bodily symptoms. That measured high. D is depression, 84, very high. HY hysteria was low, so it is not interpreted. PD, 46, that is psychopathic deviant, measured low. MF, male-female, was average. PA, paranoia, 76, very or high. Then PT, psychasthenia, it's just a general malay of being concerned and nervous and so on. SC, measured low. MA, measured low.
What is MA? SC and MA?
Must I? Okay. SC refers to schizophrenia. So if somebody had psychotic symptoms, that would measure high. MA refers to mania. So it is a person that is very energetic, euphoric, full of energy. That measured very low. And then SC was average.
You deal with that in any event on the paper?
Yes. I now, in the next paragraphs, I refer to what was relevant for this assessment, my lady. Following scores indicated in bold have relevance. The scores on the first 6 scales, VRIN, TRIN, F, L, K, and S, indicate that Mr. Pistorius' profile is valid. He accurately described his current psychological function and he did not try and create an overly positive or negative impression. Score of 68 on HS, hypochondriasis, indicates that Mr. Pistorius suffers from somatic symptoms and has a body-centered focus. This is probably due to his medical history and the stress of the current situation. Score of 84 on D, depression, indicates that Mr. Pistorius suffers from serious symptoms of depression. This was found to be consistent with collateral information and clinical findings. Score of 46 on PD, psychopathic deviate, is normally not interpreted if it is so low. However, it has value in the sense that it indicates that Mr. Pistorius does not have the personality characteristics usually associated with antisocial personality disorder and or psychopathy. This was found to be consistent with collateral information and clinical findings. The score of 76 on PA, paranoia, probably reflects Mr. Pistorius' basic distrustful disposition and the experience that he's always being watched by the media and people in general. His feelings of suspicion about the motives of people in general, and that he's very responsive to the opinions of others. This was found to be consistent with collateral information and clinical findings. The Psychiatric Diagnostic Screening Questionnaire, PDSQ. The PDSQ was administered in 2014 and with my recent assessment. It is an instrument that serves as a screening test for the presence of clinical conditions as defined by the Diagnostic and Statistical Manual 5. It has been administered more than 3,000 times and has proven reliability coefficients for internal consistency 0.86 and for test-retest reliability 0.89. It consists of the following subscales. The scores achieved by Mr. Pistorius and the cutoff score for significance is indicated. The first subscale, major depression disorder, major depressive disorder, suicidality. The cutoff is 9. In 2014, he scored at 8 and currently at 11. Post-traumatic stress disorder, the cutoff is 5. 2014, he scored at 12 and he now scored at 13. Bulimia or binge eating disorder, the cutoff is 7. He scored 0 in 2014 and currently. Obsessive compulsive disorder, cutoff is 1. He scored 0 in 2014, he scored 1 in 2016. Panic disorder, the cutoff is 4. 2014 he scored 0, currently he scored 3. Psychosis, cutoff is 1. He scored 0 in 2014 and 2016. Agoraphobia, the cutoff is 4. 2014 he scored at 4 and he now scored at 5.
What is agoraphobia?
It is basically the fear of going out into open spaces, out into public. Social phobia, the cutoff is 4. He scored 5 in 2014, he now scored at 7. Alcohol abuse or dependence, the cutoff is 1. He scored 0 on both occasions. Drug abuse or dependence, the cutoff is 1. He scored 0 on both occasions. Generalized anxiety disorder, the cutoff is 7. He scored 5 in 2014, he now scores at 7. Somatization disorder, cutoff is 2. He scored 0 on both occasions. Now hypochondriasis, cutoff is 1, and he scored 0 on both occasions. Results of the PDSQ. Based on the results of the PDSQ, Mr. Pistorius' condition has worsened since 2014. He had significant scores on the following in 2014. Post-traumatic stress disorder. This was followed up clinically according to the follow-up interview guide of the PDSQ. He satisfied the criteria for a diagnosis to be made according to the Diagnostic Statistical Manual 5, DSM-5 in 2014. This condition was found to still be present and has worsened. This result was supported by collateral information and clinical findings in my recent assessment. Agoraphobia. This was followed up clinically according to the follow-up interview guide of the PDSQ and with collateral. This fear was found to be indicative of Mr. Pistorius' general feelings of vulnerability when he was out in the world and of specific situations where his prosthesis might be a liability. For example, on a bus or a plane, or standing in a long line, or in a crowded place. This condition was found to still be present and has worsened. probably due to negative attitudes towards him from members of the public since the trial began. This result was supported by collateral information and clinical findings in my recent assessment. Social phobia. This was followed up clinically according to the follow-up interview guide of the PDSQ and with collateral. This fear seemed to point to an extreme self-consciousness and anxiety about being ridiculed or embarrassed. Although this has been a characteristic of Mr. Pistorius for most of his life, he was still able to function. The incident he was charged for and the resulting public and media attention has, however, exacerbated this underlying tendency. This condition was found to have worsened, probably due to him being vilified in the media and having embarrassing experiences in public after being released. This result was supported by collateral information and clinical findings in my recent assessment. Generalized anxiety disorder. In 2014, Mr. Pretorius measured at a high but normal level. His experiences since the beginning of the trial and his current contemplation of his future have, however, contributed meaningfully to his anxiety, putting him above the cut-off point. This result was supported by collateral information and clinical findings in my recent assessment. Mr. Pistorius scored above the cut-off point for major depression with the recent assessment. This indicates a worsening of his depression since 2014, probably due to the fact that he was unable to properly mourn the loss of the deceased, the attacks on him on social media, and the uncertainty about his future, to mention but a few. This result was supported by collateral information and clinical findings in my recent assessment. The psychopathy checklist, PCL-SV. A diagnosis of psychopathy has important implications for sentencing as it speaks to the need to protect society. The PCL-SV was administered in order to support findings made after conducting the MMPI-2 and to assist in predicting violence. The psychopathy checklist screening version was developed from the need to provide a shorter version of the psychopathy checklist revised. It yields both dimensional and categorical indexes of psychopathy, assessing both interpersonal or affective and social deviant symptoms of psychopathy within and outside of forensic settings. Results of the PCL-SV. Mr. Pistorius produced a score of 3 on the PCL-SV. Scores of 12 and below are found in people who are non-psychopathic. Scores of 13 to 18 warrant further investigation, and scores above 18 are found in psychopathic people. Having considered the result and the standard error of measurement plus or minus 3, further psychometric investigation with regards to psychopathy was deemed to be unnecessary. The result was adequately supported by clinical assessment and collateral information.
If you can just give us a more detailed explanation of psychopathy.
It is not a diagnosis found in the DSM, my lady. In the DSM, we find the diagnosis of antisocial personality disorder, which basically describes behaviors from a young age of people who start with conduct disorder and going against the rules of society. So it's a pattern that is inlaid in their personality. Psychopathy is more serious. It is accepted as a diagnosis by people in the field. There's a lot of research and literature that has been done, and these tests have been specifically designed to test that aspect. And these are people who have got no empathy, they've got no ability to put themselves in somebody else's shoes, they have therefore got no conscience, they've got no feelings for the other person. They are notoriously hard to treat or change in terms of their behavior. It is usually a lifelong pattern that is treated with exceptional difficulty. Aspects like arrogance, cruelty, non-empathic, non-sensitive are ascribed to psychopaths.
Thank you.
Risk assessment. The historical clinical risk 20 version 3. Various risk assessment tools have been developed over the past 2 decades to assess the risk for violence. These tools have greatly improved predictive assessment, particularly when used in combination with clinical instruments as is the case with Mr. Pistorius. Instruments based on actuarial principles include the Violent Risk Appraisal Guide, the Psychopathy Checklist Revised, the Psychopathy Checklist Screening Version, and the Violence Risk Assessment Scale. Instruments based on structured clinical guides include the Historical Clinical Risk 20, the VRAG, and the PCLR mentioned above. Internationally, a combination of these two approaches to risk assessment is seen as the most robust and accurate way to assess violence risk, integrative of the whole person. This approach was followed in my assessment of Mr. Pistorius. The PCLSV was already discussed in paragraph 3.4 above. The HER20 V3 can be used to evaluate risk for violence when there is a legal or clinical need to do so. It can be used for decision-making about violence risk within correctional, civil, psychiatric, and forensic psychiatric settings. It first appeared in 1995 and has been revised twice, based on research and developments in the field of risk assessment. It is currently the most widely used risk assessment tool for evaluating violence risk. In order to present the court with a sense of the comprehensive nature of the HER20, an overview of the various factors considered when applying it is provided in Annexure C. The results of the HER20, after reviewing the information gathered from the various items of the HER20, I came to the conclusions that the risk for future violence was low, the risk for serious physical harm was low, and the risk for imminent violence was low.
I ask you about the reference to low.
Yes.
Did you ever get a case where you say 0?
No, the HER does not make provision for that, and obviously we then say it's impossible for somebody to, again, offend violently, which won't make sense. So low is the lowest part of that scale for that instrument. Criminogenic needs. The necessity of considering the criminogenic needs of an offender has been pointed out by various writers in the field. In short, this amounts to a consideration of the crime-producing factors that are strongly correlated with risk. Distinction is made between static and dynamic factors in this regard. Static refers to those that cannot be changed, like a prior record or family criminality. Dynamic refers to the factors that can be changed, like an offender's values and attitudes, his substance use, and who he associates with. According to Latessa, there are 8 major risk factors for violent offending, the so-called Big 8. They are antisocial or pro-criminal attitudes, values, beliefs, and cognitive emotional states, pro-criminal associates and isolation from pro-social others, temperamental and antisocial personality pattern conducive to criminal activity, a history of antisocial behavior, family factors that include criminality and a wide range of psychological problems within the family of origin, low levels of educational, vocational, or financial achievements, low levels of involvement in pro-social leisure activities, and abuse of alcohol and or other substances. Most offenders are not high risk for recidivism because they have one risk or need factor, but rather because they have multiple risk and need factors. To understand risk, one would factor in all relevant risk factors. To affect or lower risk, one would focus on the dynamic factors. An analysis of the Big 8 factors indicated that one of these might have been present in Mr. Pistorius as a dynamic factor prior to the offence: his values, beliefs, and cognitive emotional states. In his case, it would refer to his values and beliefs regarding the possession and use of a firearm and the way he thought and felt about that. It would also pertain to his value and belief system regarding the value of a human life and how he thought and felt about that. Reports on the courses he recently completed as part of his rehabilitation program in Kgosi Mampuru suggest that he has addressed this factor successfully. All the reports are positive and indicate that Mr. Pistorius participated and cooperated fully. He was viewed in some instances as the person who carried the group. Mr. Pistorius further reported to me that he has sold all his firearms and that he never wants to touch a firearm again. As mentioned earlier, he becomes traumatized at the mere sound of a firearm being fired. Regarding the value of a human life, he stated that it was wrong for anybody to take a human life, as it is only God who should. He explained that he would like to be in a position to invest his time and experience into the bettering the lives of others. According to him, he would be in a position to do that should he be able to accept the offer of employment from the company Twin City Developments. It was seen as prudent to assess Mr. Pistorius' criminogenic needs by means of a guide based on evidence-based practices. The Carey Guide for Criminogenic Needs was employed for this. The Carey Group is an international consulting firm that provides training and technical assistance for justice system professionals and community groups. It has produced various evidence-based instruments and practices for use in the criminal justice system. The blue version of their guide employed for this assessment is included in Annexure C. As with the big 8 factors mentioned above, one possible criminogenic need could be identified as having been present prior to the offence, namely problem solving. Tends to think in concrete, rigid ways and considers few options when encountering events that require thoughtful decisions. Although the offence occurred whilst Mr. Pistorius was anxious and frightened, it has been helpful and reformative for him to analyse and adapt his problem-solving approach. This was done in psychotherapy with Dr. Hutzenberg and in the courses and workshop he completed during his incarceration. For example, problem-solving. Desistance. Desistance from crime is an unusual dependent variable because it is not an event that happens, but rather it is the sustained absence of a certain type of event. A study often referred to in the literature is Maruna's Liverpool desistance study. The results indicated some of the following differences between desisters and persisters. Desisters believed they had the ability to make good. Persisters felt doomed and condemned to deviance. Desisters felt criminality was not part of the real me, but rather circumstantial. Persisters had a commitment to crime. Desisters felt the past served as a lesson and made them stronger, and persisters felt the past predicted their criminalistic future. The characteristics for desisters found in Maruna's study have a striking resemblance to Mr. Pistorius' view on his criminal act. Evaluation and recommendations. In order to present the Honourable Court with all the factors that might be relevant for sentencing, a comprehensive assessment of Mr. Pistorius was conducted. Aspects of my assessment in 2014 were included in an attempt to provide an overall picture. In spite of the findings in research and supportive clinical experience, it is considered good practice to consider the personality, psychometric assessment results, risk assessment results, criminogenic needs, clinical presentation, clinical history and collateral information regarding the offender as well as the facts pertaining to the case. This was done in the case of Mr. Pistorius. Based on the results of my assessment, I propose that the Honourable Court take the following into consideration. The impact of Mr. Pistorius' offence on the family of the deceased could unfortunately not be assessed firsthand. Although her parents have forgiven Mr. Pistorius, it goes without saying that it must have been a harrowing and extremely painful experience for them. The following characteristics of Mr. Pistorius. He's a first-time offender, he's 29 years old, he's intelligent, he's enrolled for a BSc degree at the University of London, he has strong support from his family, he has a place of residence that can sustain him until he is self-reliant, he has a firm offer of employment from the company Twin City Development to oversee their early childhood development program as project manager. The project intervenes in the lives of vulnerable and disadvantaged children in Africa in a holistic and integrated way. The basic premise being that the first 1,000 days of a child's life is crucial in terms of providing proper protection, early learning opportunities, and basic health and nutritional needs. He has spent 12 months in prison. He has no problems with substance use or abuse. He is not antisocial or psychopathic. Statistics are not available for South Africa, but recent statistics in the USA indicate that 80 to 85% of incarcerated criminals meet the requirements for antisocial personality disorder and 20% for psychopathy. However, when the recidivism rates among psychopathic and non-psychopathic prisoners are compared, they reveal that the former are up to 3 times more likely to reoffend than the latter within a period of just 1 year. When viewed from the perspective of possible recidivism, it is an important finding that Mr. Pistorius does not suffer from psychopathy. From the perspective of risk assessment, the risk for violent reoffending was found to be low. Research based on desistant theory support these findings and point to Mr. Pistorius as a desister rather than a persister. An assessment of criminogenic needs identified 2 dynamic, changeable factors, namely, first one, values, beliefs, and cognitive emotional states, and number 2, problem solving, that were possibly present before the offence. Both these factors have been adequately addressed by way of psychotherapy and the completion of rehabilitation courses and workshops during his incarcerations. The themes addressed in psychotherapy by Dr. Hartzenberg, as indicated in her report dated 7th May 2015, and the positive reports on the courses and workshops from Department of Correctional Services indicate that these criminogenic needs were addressed. Regarding his clinical condition and general mental health, the following diagnostic statement can be made. A description of the diagnostic criteria is contained in Annexure C. Major depressive disorder, single episode, moderate to severe, with anxious distress. Post-traumatic stress disorder. Mr. Pistorius has elevated levels of anxiety that are clinically significant. These include symptoms and signs of social phobia, agoraphobia, and panic disorder. In terms of his general mental health, it was found that he had deteriorated since 2014. Apart from a worsening in his clinical condition, he has become despondent, lethargic, and disinvested, leaving his future in the hands of God. In layman's terms, one would describe him as broken. In my opinion, his current condition warrants hospitalization. He is motivated to grow in a positive way, even though he currently appears to be overwhelmed and despondent. The workshop on self-development and the course New Beginnings were specifically of value in this sense. He has taken responsibility for his actions. Crossroads and restorative justice courses he did during his incarceration and the themes covered in his process of psychotherapy assisted him in achieving this. It has always been in his nature to help others. In this sense, he has made a meaningful contribution to society and should be able to do so in future. He has expressed his wish to continue helping people. This comes not only from the person he is, but it is seen as part of God's plan for him. Although there is no onus on an elite athlete and or a celebrity to participate in charities, he was part of various charitable foundations prior to his offence. The first one mentioned below is described in a bit more detail in order for the court to get a sense of Mr. Pistorius' role and the value it had for the community. Mineseeker. Mineseeker is a foundation set up to address the problem of landmines in Mozambique. This foundation developed a technology to identify landmines from the air. Traditional means of identifying landmines were less effective. It was estimated that it would take 70 years to demine the country that way. He assisted with the marketing and logistics and helped various amputees obtain prosthesis. Also helped develop a process for selling of coconut oils and other coconut-related products by the community, with the returns going to the community. Soul of Africa, Chile Campaign, Novak Djokovic Foundation, Princess Charlotte of Monaco Foundation, United Nations Development Program, United Nations Children's Emergency Fund, Glorious Sport for Good Foundation, Beyond Sport, and Hounds for Heroes. He was a global figure with high standing and a positive role model prior to his offence, and to a section of society he still is. His fall from grace has been significant. Should he be able to regain his position in society as a person who has learned and grown from his experience, the positive effect would be considerable. He did not gain anything from his offence, and it was not committed out of avarice. Rather, his human frailties played a major role in the commission of the offence. Financially, he has been impacted severely. Looking to others for assistance in this regard has been humiliating and furthered his feelings of guilt and self-loathing. According to the biopsychosocial model of disease, he would be regarded as a vulnerable person, physically, psychologically, and socially. His physical vulnerabilities have been well documented. His psychological vulnerabilities were accepted by the court as anxiety and fear. Since the offence, he has developed a serious psychiatric condition which has become worse over the past 2 years: major depression and post-traumatic stress disorder. His levels of anxiety have also increased. He was contrite and appeared resigned to his fate. When prompted, he would indicate that he still wanted to help people, but that everything was in God's hands. He had strong feelings of unworthiness and self-loathing. His demeanor was different from how it was in 2014 in the sense that he displayed more ownership in wanting to help others then. He was less resigned, and he still held the belief that he could be worthy again. Socially, he has become isolated and fearful of venturing out in public. The isolation he has experienced since his incarceration and a fear of public scrutiny has contributed to a sense of disconnectedness. He has shown remorse and is still remorseful. His reactions and behavior directly after finding the deceased, his attempts at reaching out to the family of the deceased, and his apology during the trial are indicative of true remorse. He has been forgiven by the family of the deceased. He contributed 6,500 rand per month to the family of the deceased for a period of approximately 17 months without expecting the money back. He has successfully completed the following courses during his incarceration: Anger In, Anger Out, New Beginnings, Restorative Justice, Pre-Release, and Crossroads. He has attended various other workshops during his incarceration: conflict handling, problem solving, self-development, relationships, communication, assertiveness, and stigmatization. He has complied with all conditions imposed upon him after his release in spite of facing challenges or challenging situations, like being confronted by justice officials after his bracelet registered false alarms. Aspects that contributed significantly to the negative impact of the case on Mr. Pistorius: the intense media attention as a result of his international profile, which led to constant pressure and harassment for him and his family. One consequence of this was that his sister left South Africa. That loss of support, comfort, and companionship had a severe effect on Mr. Pistorius. Mr. Pistorius is eminently recognizable. He has had nowhere to hide and will not be able to distance himself from his offence for many years to come, even after serving his sentence. Although there were positive reactions from people since the offence, he has had very negative reactions as well. An example of this includes having to leave a local grocery store recently after another customer protested about shopping with a murderer. In future, the very real possibility exists that should he have children, that they and/or their friends might conduct an internet search, and he or they will be faced with graphic images and negative reports of the trial. He fatally shot the person he loved. That places him in that group of people who had to deal not only with taking another life, but taking the life of a family member or loved one without intending to do so. The intense sorrow, self-punishment, and inescapable guilt that follows have been with Mr. Pistorius since the moment he found the deceased in the cubicle. He had several traumatic and humiliating experiences during his incarceration. No structure to sit on whilst showering for the first 5 weeks. He had to sit on the cement floor, which led to an infection in his stumps. Overhearing the rape of a young man and finding the man had hung himself with a bedcloth the next morning. For his own protection, he was segregated in an area of the hospital ward. Unfortunately, this effectively amounted to solitary confinement. He was confined to his cell for at least 18 hours per day. Considering that the cell covers 6 square meters in size, he was basically confined to his bed. Apart from the physical discomfort, the psychological experience was that of being caged like an animal. The psychological damage caused by prolonged segregation has been well described. Hopelessness, depression, insomnia, lethargy, and a sense of impending emotional breakdown, amongst others. In the USA, isolated confinement is considered to be an area of 60 to 80 square feet, much larger than the area Mr. Pretorius was kept in. Isolation can be psychologically harmful to any prisoner, with the nature and severity of the impact depending on the individual, the duration and the particular conditions, for example, access to natural light. Solitary confinement is recognized as difficult to withstand. Indeed, psychological stresses such as isolation can be as clinically distressing as physical torture. He had experiences where warders would arrive with other people to look at him, sometimes at night. The experience was that of being on show, like an animal in a cage, experienced psychologically as humiliating and hurtful by Mr. Pistorius. Unfortunately, there was an instance where the medication he needed for his major depression and post-traumatic stress disorder and anxiety was not made available to him, in spite of it being delivered timeously by his family. This led to him having a panic attack. The late intervention by the Minister of Justice and Correction before Mr. Pistorius was due to be released on parole caused him significant distress. The fact that this intervention coincided with a petition from the Progressive Women's Movement of South Africa exacerbated his distress as it went to the core issue of his guilt and grief, that he had shot his partner without meaning to do so. Sorry, ma'am. Whilst it remains the prerogative of the Honourable Court to impose a suitable sentence, it is my considered opinion, based on my assessment of Mr. Pistorius, that further imprisonment, one, would have a detrimental effect on him as a person, considering his current clinical condition, his remorsefulness, and the fact that he murdered his loved one, and two, would not be psychologically or socially constructive. When viewing the various possibilities for sentence from a psychological perspective, and in lieu of the factors mentioned in paragraphs 6.1 and 6.2 above, the eventual outcome for Mr. Pistorius, the criminal, becomes important. In my view, Mr. Pistorius would be better served psychologically and socially if he gave back in a constructive and positive way, utilizing his considerable skills and experience to enhance the lives of others. In stating this, I am guided by my assessment of him and a consideration of the facts of the case. My opinion is also informed by the general tendencies identified by desistance research over the past 15 years, which has on occasion been stated as follows. Although these principles speak to the challenges of criminal justice, social work, or probation practice, desistance research also has implication for criminal justice processes and institutions themselves. For example, the Scottish Prisons Commission drew on desistance research in proposing a different kind of approach to sentencing, one which prompted positive and constructive payback, but which also proposed that the offender be actively engaged in discussion about the form of payback that made most sense. And then I signed the report.
Thank you, Professor. The annexes would simply deal then with what you refer to, the explanation of the terms used by you, etc.
Yes, ma'am.
Now, there was also reference to your previous report, and I'm not going to revisit that in totality, but I want to ask you something about it. That was Exhibit QQQ, the report dated 27 June 2014.
Yes.
Would you kindly go to page 28? It's something that I want to ask you about.
I'm there.
You will see in the middle of the page, you talk about the two Oscars.
That's correct.
If you can explain that first.
During my observation of him in 2014, my lady, I came to the conclusion that we had two Oscars here. The one was this super Olympian, this almost larger-than-life person who had been extremely successful and even physically tall when he was on his prosthesis. And the image of him portrayed in that sense was one that enforced respect from the community, and he had a great following because of that. So that was the one Oscar who seemed to be in charge and in control and achieving highly. The other Oscar was the one without his prosthesis, which I found to be a vulnerable, anxious man, extremely uncertain of himself when he was without his prosthesis, feeling extremely unsafe, not confident. So there was, to me, a clear difference between these two, I call it two Oscars, between these two people, one with the prosthesis, one without prosthesis.
Now you have seen Oscar recently. Does he fall in any of the two categories?
My lady, unfortunately, I feel his condition has worsened. So what I saw now was an Oscar. I don't want to talk about a third Oscar, but perhaps that would be accurate, that really almost has given up. His spirit seems broken. I know it's a late term, but clinically has deteriorated. One has to prompt him to get some semblance of hope for the future. His functioning has deteriorated. He forgets things. He forgets that he has already told you things, then he repeats them. I had to wake him up twice when I wanted to consult with him. Then he had either forgotten or he was just too tired to get ready for the consultation. This departed from how he was in 2014. So as a clinical psychologist at this time, my opinion is that he's quite ill. He's got a severe condition. I would go as far as to say if he was my patient in private practice, I would admit him to hospital. And that's the Oscar we see now.
Lady, I see it's 11:10. It's just one aspect I want to clear that might save time. If I can ask for a 5-minute early adjournment.
You want the excuse me, the adjournment now?
Yes, ma'am.
We'll take our 15 minutes adjournment.
Thank you, ladies and gentlemen.
directly saying, please give us space and privacy. You didn't do your job in any case. Do you know that?
I don't know that.
That's not the person that has given up on life. That's the person in charge of the situation.
Lady, if we understand the symptoms of depression, post-traumatic stress disorder, severe agitation, irritability.
Good. Whilst you're saying that, Professor, please excuse me. I got your report before you started testifying. I'm trying my best to save time, so I'll be jumping around. PTSD, post-traumatic stress disorder, is a treatable illness. Am I right?
Yes, it is.
It's manageable. If you take your tablets, it's manageable.
No, not only if you take your tablets, you have to be in psychotherapy. It's very important.
But it's manageable.
It's manageable.
Good. You know, the incident with Colonel Van Aert was so bad that council phoned later to apologize. You accept that, right?
Except that, my lady, we have instances of people with PTSD that go way beyond the normal controls of behavior. It's a part of the condition.
But
So their behavior is informed by this condition. So I'm not too surprised about this in that context.
I see. Let me put it into my context. So he would be prone to being irritable and aggressive. That's part of the PTSD, if he's not in prison. The answer must be yes.
He will be prone to being irritable, agitated, anywhere and everywhere. The condition is with him all the time.
Okay. You see, I still want to... Did the accused inform you about his interview with ITV?
No, he didn't.
Did you pick it up in the media?
Oh, yesterday in the paper that there was such an interview, going to be one or not.
Now, let me test you. What did you find out about this?
Just that he had an interview with ITV.
And did you ask anybody what's this interview about?
No, I saw this yesterday for the first time in the papers.
If I tell you that what I've read in the papers is that he's given a version of the events, would you be surprised?
No, I won't be surprised.
So he would rather give it to the TV than to court.
Suppose he feels he has given his version to courts and been tested on it, my lady.
You see, I'm jumping, but let me just go for whichever answer you give. You discussed the two judgments with the accused, am I right?
Yes, I would have.
Okay. Now, you would have seen the one thing that stands out in both judgments is that the accused was a poor witness and that there's no acceptable version before court.
I saw that he was a poor witness, yes.
And did you discuss it with him?
No, I didn't.
I see. But then you have to accept that both the appeal court and this court said, well, let me rather tell you what the appeal court said. The appeal court said, one really does not know what his explanation is for having fired the fatal shots. You've read that. Did you discuss it with him? No. One does just not know his true explanation for firing the weapon. Did you discuss it with him?
No.
You see, why I find this strange, but I have to do the third. And he never offered an acceptable explanation for having done so. You've not discussed that with
No, I haven't.
in the prison. Let me just go back. Have you discussed the incident with Mr. Pistorius again?
No, I didn't
You
discuss
didn't.
it.
So you don't know if it was still an accident that the gun went off.
I stuck to the judgment of the Supreme Court of Appeal. That's why I felt I did not have to discuss it with him again.
I know what you think. I'm asking you.
Yes?
You did not discuss the fact with him that it could still be an accident.
No, I didn't.
See. Why?
Because there's a judgment. It, in my view, did not matter anymore what he thought about it. It mattered what the court said.
You see, but you at length deal with remorse,
Yes.
his understanding of what happened. Did you discuss that with him?
I discussed his insight into his part of the incident to see if that part of his criminogenic need was addressed.
I see. And I acknowledge the criminogenic need of the accused. But let us just go one step further and ask you that, having been in courts, having testified, you know what the courts would expect of remorse.
Yes.
You do? What?
There must be evidence from the offender's behavior that points to remorse. Like I said in my report, I found that in the initial judgment already. It was found after he found the deceased, how he acted. I remember Dr. Stipp's evidence was accepted as what he saw there was a man that was severely distressed, trying to save her.
But it
There
goes
must be other actions, sorry, like
No, no.
reaching out to the family, understanding that they had pain, what he had caused them.
But isn't the main thing acknowledging what you did? Being
Yes.
truthful about what you did.
Yes, yes,
Truthful to yourself and truthful to the world.
yes.
And he hasn't.
I wouldn't say he hasn't. He has said, he accepts that he took her life.
You see, there's a difference as far as remorse is concerned. I accept I took her life
Yes.
and I murdered it. There's a difference. You agree with that?
Well, it is now about which words we're using. Did he say he murdered her or killed her or took her life? I'm just saying that his disposition is and his thoughts is, were, he killed her, he
Yes.
took her life.
That's why
Yeah.
I will argue that it can never be true remorse. It can be, I'm sorry for myself. I took her life. That could be, isn't it?
In that instance, it would be strange, my lady, in a sense, if one looked at him holistically and clinically, his condition, to then say he does not have remorse. I can't bring the two pictures together in my mind. If we are saying his condition and how he has deteriorated the past 2 years is only because he's feeling sorry for himself, I can't clinically substantiate that.
But you see, again, have you had access to the dosage of medication that was prescribed whilst he was in custody?
I had access to the medication he's now using.
Okay, but let's
Yes.
go. You, Mr. Professor, you said that he's deteriorated the last 2 years.
Yes.
Okay. Now I'm saying for one of those last 2 years, he was in prison.
Yes.
Have you had access to the medication that he took during that time?
He gave me the names of the medication, but I could not confirm it. It's just what he said.
Do you have any indication of the dosage of the medication?
No, I
that he
don't.
took? Do you have any indication if it was increased, the amount of tablets he had to take?
Since when?
Whilst he was in custody?
No, I don't.
Yes, see. Now, whilst I'm dealing with this, have you had any access to correctional service documentation pertaining to the accused incarceration there?
Yes, in the sense that I had the reports on the courses he did and the other documents I mentioned earlier on, the pre-sentencing plan and those kinds of documents. Recommendations to the parole board, those kinds.
Any indication about all his temper tantrums?
The one report by Ms. Bayi, a counseling psychologist, mentioned temper tantrums, verbal aggression.
Did you discuss it with him?
Yes, I did.
Now, did he tell you that he got so agitated in talking to Sister Mashabane that he banged the table in her presence?
I'm not sure what period that would have been. When was this? When he was in the first month, the second month?
No, in January. No, it's in January of 2015.
Yes, he didn't discuss that incident.
But let me then tell you about it, because you made lots of recommendations. He got so upset with Sister Mashibani that he approached her in the office, he was shaking, and he banged the table. Do you know anything about that?
No, I don't.
Did you discuss Sister Mashibane with the accused at all?
No, I didn't.
Were you in court when Mr. Pistorius walked in this morning?
I didn't see him walk in.
Were you in court when he walked towards where he's sitting now?
No, I didn't see that.
Now, I'm going to tell you what happened, and if you can. Mr. Pistorius walked past all the corrections service people, greeted them by hand, except Sister Mashibane. Did you see that?
I didn't see that.
Do you know that Mr. Pistorius was in prison, was allowed to see a psychologist?
Yes, I do.
You know that he was allowed to see, apologies, Malele, I want to rephrase the question. Do you know who Dr. Eunice van Wyk is?
No, I don't.
You have no idea who Eunice van Wyk is?
No, I haven't.
Do you know which doctor visited Mr. Pistorius in prison?
No, I only know of his psychotherapist that visited him, Dr. Hudson.
So you never asked him if he had access to his private doctor?
No, I didn't. I asked him if he had access to his medication, because that obviously would be important pertaining to his condition from my perspective, but not...
I find it a bit strange because your report deals with the fact that he had blisters on his...
infection in his stumps.
Yeah.
Yes.
Did you ask him who treated it?
No.
Why not? I mean, that's important to know how the man coped in prison.
I accepted he would have access to medical services and that it would be treated in that way.
So then it's just a by and by issue. He had an infection, it was treated.
Yes.
So we shouldn't see anything into it.
We should see what it caused, the stress it caused him psychologically. That's why I mentioned it.
I see. But he was seen by Dr. Eunice van Wyk. Do you know that?
I don't know that.
And by mere coincidence, it's not only his private doctor, but a direct family member. Do you know anything about that?
No, not really.
So you wouldn't be able to say if the fact that she was a family member was disclosed at all?
No.
Okay. Apart from the two people you had access to, as far as correctional service is concerned, Mr. Lehoko
Yes.
and Ms. Bai,
Yes.
you saw nobody else?
I didn't see Ms. Baya, I just read her report.
Oh, you just read
I
it.
only saw Mr. Lehoko.
Mr. Lehoko is a junior official in the department that arranges the interventions and things.
Yes, I saw his signature on some of his reports, and that's why it was important to me to talk to him, so that he could convey to me how Mr. Pistorius handled himself with these courses that he did there. And he actually told me that he saw Mr. Pistorius almost every day.
You said that you gave evidence that the family of the deceased has forgiven Mr. Pistorius.
Yes, ma'am.
How do you know that?
I have a letter that they wrote to the parole board.
But apart from that, you have nothing.
No. I requested to speak with them, to try and go there and ask and find out, but it was declined.
But do you know that Reva's mother wrote a book?
Which book, Melanie?
She wrote a book. She only wrote one book.
Yeah.
Do you know of the one book she wrote?
No, I don't.
Okay. A mother's story. You've never read it, or...
No.
Now, forgiveness is a wide word, isn't it?
I suppose so.
Page 30 of that book, sir, deals with forgiveness. I've forgiven him. I have to. That is my religion. It's not healthy to carry evil thoughts about him because it will only destroy me, eat me up. But I can't forget what he's done. That's what she said. She's forgiven him for her sake, not for his sake. Do you understand that?
Yes, I think that is what forgiveness is.
For her sake, not for his sake.
It is how we get over the pain that she must be feeling.
But
Forgiveness is one way of getting through
Yep.
that.
But it's for her.
Yes,
Yeah.
yes.
You say at line 662 of your report that Mr. Pistorius has taken responsibility for his actions.
Yes.
662 of Exhibit SA.
Yes, my lady. Line 662. Do you have that, sir?
I have it in front of me.
Right. I will. Okay. The actions that he took responsibility for is what?
I killed Riva.
That's all. He never. He could have killed her with a gun, accidentally went off, like he's testified.
No, he conveyed to me that he killed her. He took her life and he shouldn't have. That is what he conveyed to me.
Oh, let me just see that. So he said he'd fired intention.
No, 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 no.
And then he
No,
can't
no.
hold him words. That was not the evidence. He said he killed. And then he repeated, he said he fired intentionally. There's nowhere in his evidence. That's misleading.
It's part of a question, Malay. That is, I could have been more thorough and said, did he say he intentionally killed her?
He said he took her life. I killed her. It was wrong. And what was crucial to me was that even though he didn't know it was her behind the door, he still accepted that he killed her.
Okay. Now, so this thing you discussed with him,
Yes.
but when I asked you earlier on, you said you never did, about the incident.
No, I discussed the judgment with him. I said I discussed the judgment with him, and that part in the judgment was important in terms of where is his thinking now,
But
in terms of his criminogenic needs. How is he talking about this? Is he accepting his role in the whole incident? How is he talking about that?
And
That is,
so, did he say anything about, so you discussed the fact of the finding
yes,
of dolus indeterminatus, the fact that he didn't care who was behind the door that he just fired.
yes,
And he said he's sorry he killed Riva.
no.
What did he say?
Those two ideas are slightly different. When we discussed Riva, I wanted to understand if he understood and accepted that even though he didn't know it was her, he still killed her,
Okay.
took her life, and he's responsible for
Does he
that.
understand that he
Yes,
committed murder?
yes, he does.
In what way?
I said in my report he accepts that nobody should take a human life, only God. He accepts he took a human life when he shouldn't have.
But
That's
that-
murder.
But no, that could be culpable homicide.
It could be, but in his case, after the judgment of the...
Yeah, but that is your view, and that's not his.
No, it's his. I discussed the judgment with him, my lady.
That,
And I asked him, the appeal court judge said you murdered Riva.
and he said what?
Do you accept that you murdered her? He said, yes, I murdered.
In what way? You just now said he accepted he murdered her because the judgment said so. Did he indicate to you how? What he did?
We know what he did. He
What
shot
did
her.
he do?
He shot her.
How? Does he agree, let me just say, does he agree that he armed himself with the intention to shoot? Lady, may I just get the portion? That he knew there was somebody behind the door,
Yes,
that he then intentionally fired 4 shots into that door.
Yes, yes, my lady.
He does.
Yes.
He hasn't said so to this court. He's got lots of other versions. That version that you're giving now is another one.
My point being there, my lady, is that we have had 2 years. We've had courses, we've had inputs, we've had challenges in psychotherapy. And that is why my discussion of the criminogenic needs on the values of human life, his thoughts concerning that, his cognitive emotional states about that, has that shifted? Now what I'm seeing now is what I'm reporting now. Then it would be a departure from that time, yes, I suppose.
Yeah, but you see,
but then we must perhaps accept that he has grown or has moved.
or we can accept that he's just given another version.
No, he hasn't given another version, my lady. He accepts the version that the Court of Appeals put forward. He accepts that he killed her by shooting her.
Did he accept the version, or did he say that what the court said? I did. I walked there. I thought I'm going to shoot if there's somebody in the bathroom. When I got there, I shot. Does he accept that?
Yes, he accepts.
What does he accept?
That he went there, firearm in hand, heard a noise, and then shot through the door.
No,
and killed
you
someone.
see, Mr. Scholes, you've given evidence before. Listen carefully. Does he accept? He armed himself with the intention to shoot somebody in the bathroom if there was somebody. When there was, he did. There's a difference.
I did not discuss that part of the version with him in terms of his initial intention when he picked up the firearm. That, in my view, was sorted by both the judgments. I wanted to understand if at this time this man sees what he did, if he accepts responsibility for it, if he understands that he killed her in spite of not knowing that it was her, that it was murder, and that it was wrong.
But the one thing you said 3 times, he killed a loved one without intending to.
Yes,
So what are you saying? He never intended to kill her.
that's correct.
Not that he never intended to kill a person.
That's correct.
So he intended to kill a person, just not her.
He didn't know it was her. Yes.
Is that your view?
That's my understanding of the appeal court's judgment, that they said
See, Mr.
he killed a person not knowing it was Riva.
You
That
see,
is what I'm saying.
Mr. Scholes, if it was anybody else
Yes.
that hasn't given evidence in court on so many times, I would have accepted this. Listen to the question. You said he killed a loved one without intending to.
Yes.
Okay. Does he accept that he intended to kill another person?
That's correct.
He intended to kill another person.
Now we go back to the version. He went there and was frightened and anxious, heard a noise and shot. It was then found that he intended to kill. My lady, these are perhaps now legal nuances that I don't understand
Yeah, but
properly, but this is my understanding.
Okay. Let me just ask you, in your discussions with Mr. Pistorius, because I would like to have an answer.
Yes.
Did he admit that he intentionally fired towards somebody?
He described it to me as he heard a noise and he shot at the door, fearing that his life was in danger.
Yeah.
That-
No.
Yes.
That version we have.
Yes.
I heard a noise, I shot at the door. That we have.
Yes.
I'm asking a different question.
Yes.
Did he, and just the answer is yes or no.
Yeah. Yeah.
Did he indicate to you that he intended to shoot through the door at the person?
If I may intervene, I'm sorry, but we're now very technical because I can also discuss this for half an hour. It's dolus eventualis. The way it's put as dolus directus. He leaves out the lower aim, not aiming chest high, and just takes one sentence. And that sentence that he deals with encapsulates the dolus directus. And it's unfair to this witness. Let him put to the witness that the real finding was something different, and that is that he foresaw the possibility and reconciled him, not that he had direct intention to shoot the person behind the door. It's put very differently, and I think it must be corrected.
As a court pleases, my lady, I'm not arguing the judgment with this witness. I'm asking him about his interview with Mr. Pistorius. Now, he could say anything that even outside the scope of the judgment, and that would be important. So, my lady, I'm not arguing with this person about the details and the technicality. I'm cross-examining this witness in relation to his interview. That's all. Mr. Pistorius could have said anything.
Yes.
But
Mr.
he asked the question, did he intentionally kill him? Then put it properly. Say, did he tell you that he foresaw the possibility and he reconciled him with that possibility, notwithstanding that he was not shooting chest high? That should be the question, but it's put as one proposition that he intentionally killed the person. And that's notice directors, that's never the finding, and that's misleading.
My understanding is that he wants to know what was discussed in the interview.
Yes, that is so.
Never mind what the judgment said.
That is so, but then he can't put it in that way, as if that was the finding.
Okay.
That's the difficulty that I have.
Lady, with the utmost respect, I never did. I never put a finding to this witness. I said, did Mr. Pistorius indicate to you that he intentionally shot at a person in the bathroom? That's it. I never discussed the judgment, but now we've had lots of argument, and it will be interesting to see what the answer would be now.
I'll allow it. Just
Okay.
proceed,
Let me ask you the
please.
question. After all this argument, did Mr. Pistorius indicate to you that he intentionally shot at the door knowing there was a person in the bathroom?
Yes, if you put it that way, he did.
He did.
He understands now my current assessment that that is exactly what he did.
You see, that's a different, that's his first admission through you.
It might be, my lady.
And I'm not accepting that because I would have liked to test it.
Why, just 1 minute. Why do you say you're not accepting it? You don't have to accept it.
I don't. Yes,
No.
I don't have to.
You don't have to.
Yeah. No, no.
Yes.
In cross-examining a witness, I'm saying that, may I put it properly? And if I still transgress, the court will. I put to you that that's the first version of him intentionally shooting at the person that we've had in this court. And I would have liked to test it, to give it himself, not through you. Because I think that he perhaps intended more. Therefore, I cannot, I want to move away from the word accept, but the best you can do is another version by Mr. Pistorius. Do you understand? Good.
Yes.
Now, let us deal with apology. I was
He was trying to reach out.
We'll deal with that.
Yes.
Now, then he was sentenced and he went to prison.
Yes.
Was released from prison. Do you know if he then tried to make contact with him?
No, he didn't. I asked him about that, and he said no, he didn't again.
Wasn't that the opportunity if he really wanted to do it?
It might have been. He felt at that point, he explained to me that he would perhaps do this at a later stage. I think at that point he might have thought he would be testifying in this hearing. I don't know. But he said
But you
he
see,
just...
you
yeah.
say he might. What
Yeah.
you're saying is you speculating. You're giving your
Yeah,
own version.
that's what he said. No, he said he might do it at a later stage, but
Yeah,
not at that.
But not the reason why. The reason why that he might testify, that's coming from you.
Yes, that's what I'm thinking. I wanted.
Yeah.
Yes.
So, but please let us just deal with being a professional and things you heard. And now,
As a professional psychologist, I make assumptions when people tell me things. It's part of our work. We try and understand why is it that they might possibly say this. That's all I mean by that.
now, do you know that, in fact, there was a letter written to the legal team of the Steenkamp family. Do you know that?
By whom? By Mr.
By Pistorius'
Yes.
legal people.
Yes.
When was that?
I'll have to check.
I can help you. In April. Only in April. Just before, in preparation for sentence, they wanted to meet. You know that.
Yes.
But your explanation for not having done so earlier is he said he will do it later.
Yes.
You see, you volunteered the evidence about the money that was paid over.
Yes,
What do you know about the money that was paid over?
the 6,500
Yeah.
rand per month.
Yeah.
Only that he had been paying that since directly after the incident for about 17 months, that then stopped, and that he doesn't want it back.
Do you know that initially there was an agreement that that would be part of a payment of a civil claim if that would happen?
No, I understood there was another discussion about the possibility of a civil claim, and that a different amount, a once-off amount was involved,
No.
and that then went wrong.
Okay. No.
Not the 6,500.
Now let me
No.
help you. The 6,500 was viewed as part payment of the amount of a civil claim. You didn't know that.
I did not know that. That was not his understanding.
Then the 300 and something.
Just 1 minute. I'm not following this. It was viewed by whom?
Yeah.
By all parties concerned, madam.
Okay,
I'm putting it that strongly. By all parties concerned.
correct.
And you know that there was an agreement that it would be kept confidential,
No, I don't.
you know,
No.
and that it then came out in the trial from the accused side against the confidentiality
Yeah, I don't know that.
agreement. Okay. You see what I find strange, but I'm just testing it, Mr. Professor. I know that your report deals with the accused and what's good for the accused,
Yes.
and you haven't taken the other factors into account in this report.
Which other factors, ma'am?
What do you say is other factors for sentence?
Well, the crime itself,
Yeah.
and then the community.
Yeah. But you haven't
Impact
discussed
on the community. In terms of the impact on that I feel is
Yeah.
for the court to do.
Yeah,
I
no,
don't
I'm
want
not
to
asking
go
questions
there.
about it. I'm
Yes.
saying, for once I'm agreeing with you. I'm saying this, you deal with only the accused
Yes,
and not the other factors for sentence.
yes.
Now, in dealing with that, I just find it peculiar that you place a lot of emphasis about the negative media
Yes, Maddie.
as a factor that impacts on the accused.
Yes.
So much so that in line 758,
Yes.
you even indicate that his children may in future search the internet and read negative reports of the trial.
Yes, Maddie.
But you never dealt with him explaining that to his children. Don't you think the fact that his father murdered somebody is more detrimental than negative reports? And why do you stick with negative reports?
We were discussing his future, and I wanted to get a sense from him how he saw that future, positives and negatives. This came out as one of the big negatives, Melody, that because of who he is and because of all the media attention that this trial has caused, it is possible, and one only needs to look on the internet. The graphic images are unfortunately there. So it's possible, he said, if I should ever have children, I'm quite worried. What if they just Google and they see these graphic images of what their father did? So he mentioned that as a concern for his future.
Now let's deal with the views you had or recommendations, things that the court should take into account as far as his time in prison is concerned. Now that starts with 764. The fact that he was confined to his cell for 18 hours a day, that you covered that with anybody else, or this what the accused told you?
No, I covered it with the official, Mr. Looko. I confirmed with him because he said to me he had seen Mr. Pistorius almost every day.
Yeah.
It seems they had struck up some kind of...
Yeah. But if I put to you that we will need evidence that Mr. Pistorius was not confined to his cell, what would you say about that?
Look, he explained to me it wasn't every day, all the time. There were instances where he was allowed more freedom, but in my understanding, they were minimal.
Okay, wait. So we have to then, he was confined to his cell for at least 18 hours per day, some days. Can we change your report to say some days?
Most days. That's my understanding.
But
Yes.
let us just do what you want, most days.
Yes.
Were you ever there at the cells where Mr. Pistorius was?
No, I didn't go there.
Now, if I put to you that Mr. Pistorius had his cell where he was kept in, what you described as 6 square meter in size, was open during the day. He could move in the section where he was kept. What would you say about that?
I understand that, Belady. His fear, however, of coming to some harm made him confine himself to his bed most of the time. And my understanding was not that that door from his cell to the other section was open so often, as is now being put. I had the understanding that he was confined to his cell, that little area, most of the time.
Okay. And I put it to you that, you see, I have to deal with your answers. Did you ask him about the section where he was kept? How many other people were in that section?
Yes, I did, Belady.
Only one.
Yes,
That was Mr. Kretcher.
yes.
Okay. So, in his section, there was he had no fear of harm, or was he fearful of Mr. Kretcher?
No, he had fear because somebody did come through into his section and assault him there.
Oh, okay.
So it was possible, and it actually
And he
happened
reported
according
that?
to him.
He reported that?
Yes, he did.
No, it's not true.
I confirmed this with his psychotherapist who saw him
But
the
you
next
see,
day or two and went
I
through
would-
this with him.
I will lead evidence that in the complaints register, that's just not true. It's a lie.
I'm assuming he reported. I don't say he said he did.
So
That's
you're
what I'm
assuming?
saying. Yes.
Okay. But he would have.
Possibly. One has to consider that if you report transgressions or problems in there, you might get more problems. He was quite aware of this, to keep himself low profile, to behave, to follow the rules, not to upset anybody, even the officials.
No.
That was,
No. Is that, again, your assumption?
This is the sense I got from him when I saw him.
Okay. A sense is an assumption.
Yeah, it's partly assumption, but it's an understanding.
Okay. But I am possession of the complaints register. He complained about anything. He was open to complain, and he did so often. What do you say about that?
I don't know what he then complained about. Perhaps the instances were different in intensity. It's a different thing to say I've been assaulted by somebody who shouldn't have come into my section versus I don't have soap or whatever. That's I don't know what the other complaints are about.
But let us just then deal with, if the gate to the section, if that gate
Yes,
was locked,
yes,
he could move around in his section
yes.
without fear.
Yes, if it was locked.
And because the only other person was Mr. Kretcher with him.
Yes,
And he had access to Mr. Kretcher. He could talk to him.
yes.
So he wasn't in solitary confinement, as you want to explain.
I go towards solitary confinement because my understanding was that he was confined to that 6 meter square cell for most of the time. That is what I'm.
Okay.
He was isolated.
Well, if that's not true, then solitary confinement should not even be a factor that we take into account.
Suppose it now depends on the definition and the area, how big it is,
Okay.
how much contact. My understanding was that he had contact with some of the officials on a
Yeah.
daily basis and then with whoever was next to him because it wasn't always only Mr. Kretcher.
And he had access to an open area where he could play ball or just be outside. You know that?
That, my understanding, was extremely limited. There was a specific courtyard that he could go to, but again, he felt fearful. something might happen to him there. He did go there once or twice, as I understand, but not again. And it was the small concrete courtyard, not the bigger area.
Okay, so I just want to test what the accused said to you. He said to you he had access to the open courtyard once or twice.
Yeah, on occasion.
No, no.
I don't know, I want to put a number to it. I said once or twice on occasion.
No, no. You see, I'm testing you on your evidence. And I want to write that down. So let me write down what you want to say. He had access to the courtyard once or twice.
On occasion.
On occasion. What does that mean?
I don't know how many times specifically.
Whenever he wanted to, what will you say about that?
No, that was not my understanding.
Okay. But can you deny that?
No, I can't.
Okay. So you cannot, let us start. The fact that he was confined to his cell for 18 hours a day, that is also just your assessment? Or do you have anything more? Accused said that to you?
Yes,
He said that to you?
yes.
But you didn't change it to most days?
Yes. My sense that I got from him was that he was there for the majority of the time. That's
In
most
his
days.
cell?
Yes, in that confinement.
Would that include him lying on his bed whilst the door's open? He could go out if he wants to.
No, my understanding was that he could not go out, that it was locked, that he was in that 6 meter square area. He explained to me at one point that he tried to do some exercise there just to kind of get his body into a better state, but that it was so confined that even that was difficult.
Did he tell you that he had access to a gym?
Yes, he did.
So unlike, I mean, he could walk out of his cell and into a gym.
But there was no gym. That is the problem. He had access, but there was nothing that he could use to practice or train.
But then,
That's my
then he
understanding.
brought in weights and things.
He wanted to, my lady. My understanding is that he arranged that the delivery of various gym equipment would be made and sponsored by him or family. That did not happen. Something went wrong with that process, so that did not happen.
So are you saying that he never had, is it your version that he had never had training equipment in his gym?
He said to me there was at one point a few limited types of equipment, but I did not get the sense that there was a gym in the sense that you could do 5, 6 or 7 different exercises with different machines or something. No.
Yeah, you see, that's not what I asked you. I never said the different machines. I said he had access to a gym where he could train. He had, am I right?
The concept of a gym in my mind, my lady, is a gym. So there are various instruments, different types of activities you can do in a gym. That was not my understanding. My understanding from him was it was an area, a room, and there were a few limited things that he could use.
And he was,
not weight.
and he was him and whoever was with him, say Richard, they were the only people that had access to it.
Yes, that's correct.
So you could train in privacy.
Yes.
Now, if you're saying in point number 2,
Which line?
769. Sorry, yeah, 769. We're still dealing with.
Yes, oh yes.
Can you explain the word finding the man had hung himself?
He saw the man
That
next morning.
did not happen. That's impossible to have happened and did not happen. Is that what the accused said to you?
Explained, yes, that he saw him. hanging.
Did he explain? Just, you see, I will lead evidence regarding this, but where did he see? Did he explain that?
He explained to me that he was hanging in a doorway and that people were walking past this body, even moving it to the side to get past for quite a period of time. I don't remember if it was 30 minutes or 50 before it was removed. That is what he explained to me.
And he saw it all.
He saw the person hanging. Yes.
That did not happen. But perhaps if Mr. Pistorius was here, he could have testified to that. Now, the dramatic way in which I read 789 to 792 is that the warders would just bring people there to look at him.
There were such instances, yes.
Let us just, were such instances. Did he indicate how many, how frequently?
He only mentioned to me 2 instances specifically, and the warden was accompanied perhaps by 2 or 3 other people. One instance was after hours. He still explained to me how they put on the lights, they could see him.
But you know, do you have any experience of prison and conditions?
Yes, I do, mate.
Do you have experience that health inspectors and lots of other inspectors would visit prison and prisoners?
I don't have experience of that.
But you know it
is
happens.
so. I assume it is so.
Yeah, you assume it is so.
I don't expect-
No, that in fact happens. There will be visits by health inspectors and other inspectors of inmates, and they'll all be viewed by these people. It's not something that happened to this person alone. You cannot deny that.
That is not the context in which he explained it to me, my lady. Context was that these were people, either family or friends, that were brought, and he was showed out. That is now Oscar. And his experience of it was that he was being viewed.
Well, that is his view.
Yes.
Do you know of, you mentioned at 739, now, did you discuss the way Mr. Pistorius received his medication in prison?
No, I didn't discuss how he received it.
Who gave it to him and those kind of things?
No, he's in the hospital section, so I would assume it works like any hospital section where these medications are administered at a certain time or handed to him by the staff.
I see. Do you know of an incident where a visitor wanted to hand over medicine and it was denied by Sister Mashabane?
I don't know of that incident, my lady.
Okay. Do you know about an incident where Mr. Pistorius' prison cell was searched and illegal medicine found in it?
No, I don't know that.
Did he not tell you that?
No.
I see. It happened, in fact, on the 19th of July, where there's an entry. Patient was found with 28 Molipaxum, 50 milligram, and 14.5 Cipralax, 20 milligram tablets in his possession during searching of his cell. Don't know about that.
No, I don't.
19th of July, when? What year?
2015, my lady.
Thank you.
Milady, I've reached a stage where I can continue without having had assistance from psychologists and psychiatrists to look at the report. Having received it this morning, I beg leave that we stand down. I'll do so as soon as I can. I would not have any objection if we carry on with other witnesses in the meantime, but if it's the court's view that I should do that, I would rather do that. But I need my experts just to look at the report.
You have to be very specific. What do you want this court to do?
Lady, if I have my will,
Pardon?
if I could say, my lady, I would say that perhaps we stand this witness down. If the defence would like to carry on with other witnesses, that we carry on tomorrow. If not, my lady, that I'll be granted. May I just have a look at the time? Till 2:30, my lady, to consult with witnesses.
You want us to stand down until 2:30?
Yes, my lady. The witnesses still have to get here.
You are aware that we usually adjourn at 3 o'clock in this court?
Yes, my lady. I'm sure that there is a possibility
You'll be
that
done
I would
in-
not have more questions than half an hour would dictate.
What's your time now?
May I just look at this? It's 12:25, my lady.
Is there an objection to us standing down?
There's no objection to that time.
Thank you very much. We'll adjourn until 2:30.
Email of Stanley of Rising for Sukumari. Silence, ladies and gentlemen. Thank you.